Okay, set for argument in the state of Ohio versus Stephen Atkinson. It is case number 19CA011466. Both parties are present with counsel, so each of you will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. I keep track of the time, so if you're going to reserve rebuttal time, let me know and I'll advise you as you get close. We use the front podium for arguments, so please keep your voice up and stay at the podium during your argument. If there are children or involved in the case, please refrain from using children's names or victims' names. We prefer you use initials. Having said that, you should know the court has read the briefs in this matter and we are prepared to proceed if you are.
May it please the court, I'm Jack Bradley. I represent Stephen Atkinson. The thrust of this case is that a search warrant was executed in this particular case, and Mr. Atkinson's counsel during his pending case was retained, I believe, in August of 2016. Mr. Atkinson was arraigned on August 22nd of 2016. It wasn't until June 4th of 2018 that a motion to suppress was filed. I think that it's very clear from the record that the main issue in this case was the results of the search warrant, because that particular search resulted in a crime, a first-degree felony with a major drug offender specification, which carries a mandatory 11 years in prison. So, although he was charged with other offenses, the search of the residence was the primary or the main crime that should have concerned defense counsel in this case. The trial court denied the motion to suppress on June 15th of 18 as being untimely. As this court is aware, a motion to suppress must be filed within 35 days after arraignment, although that time can be extended if a motion is made with the trial court for good cause shown. That motion was not made in this case by defense counsel, and I believe that's why the trial court denied the motion as being untimely. Defense counsel, approximately 2 months later, on August 1st of 18, filed a motion for reconsideration, and the court did grant the motion for reconsideration, but denied a hearing and simply overruled the motion. Surprisingly, defense counsel did not ask the trial court to make findings of facts or conclusions of law as to why it was not granting a motion in the case. I think that should have been done by defense counsel if defense counsel was to be effective. I think that the strongest argument is made by the state of Ohio, and that is that the motion to suppress did not include sufficient information to warrant a hearing on the motion to suppress. And as the state points out in Franks versus Denver, defense counsel's motion to suppress must include a substantial offer of proof to substantiate the claim that the search was not a valid search, or that the search warrant was not sufficient. There were no affidavits attached to the motion to suppress, nor were there any sworn reliable statements of witnesses to support the motion to suppress.
Counsel, can I back up a second?
Yes.
When the motion for reconsideration was filed, what reasons did trial counsel give to the court? Usually it doesn't go over well if you just say you were wrong, think about it again. I guess what I'm asking, did he talk about the slowness at which discovery was given to him or anything of that nature when he asked for reconsideration?
Not really, Your Honor. It was just basically that the court should reconsider the motion and grant a hearing on the motion based upon the original motion to suppress
And that was it.
And the trial judge granted the motion for reconsideration the next day, but also denied it the next day. And as I'm arguing today, I think that they should have at least asked for a finding of fact and conclusions of law. So, I mean, the search warrant and the search warrant affidavits were filed with the court on March 21st of 2018. So it wasn't until almost 2 months later that defense counsel filed their motion to suppress, again, not asking for leave of court to file the motion to suppress. And it's my belief that I think that the search warrant and the affidavit are part of the record in this case. I think the state has argued that I couldn't attach them as exhibits, but I believe that from the discovery, they were filed and made counsel-only documents in the record. So I believe the search warrant and the affidavit are part of the record in this case and can be reviewed by this court. But without asking for findings of facts and conclusions of law or supporting the motion to suppress with either affidavits or witness statements, I can see how the trial court could deny the motion to suppress without a hearing. I think that amounts to ineffective assistance of counsel in this case, and especially in a case where someone is looking at a mandatory 11 years in prison. Defense counsel should have been more diligent in asking that the evidence in this case be suppressed and done a little bit more work in supplying the court with information as to whether or not the person who was living at that house on Sterling Road in Lorain, in fact, was living there alone, or whether she was living there with Stephen Atkinson, whether or not anything belonging to Stephen Atkinson was at that residence. I know that there was allegations that his car was seen parked there. There were allegations that there were trash pulls and that there were presumptive tests on some of the baggies that were pulled from the trash pull, that the items presumptively contained cocaine, but I didn't see anything in the record that they knew in fact that there was cocaine in those baggies when they applied for their affidavit for a search warrant. So I think that there was a lot of information that could have been included in the motion to suppress the evidence to negate some of the information that was in the affidavit for a search warrant for the trial, for the independent magistrate to grant that search warrant. So if they had that ability to do that, they should have supplied that to the trial court, so the trial court would have known whether or not there was enough information to warrant a search of that particular residence. I have to tell the court that after the police got there and had access to Stephen Atkinson, that he admitted that what was found in the residence was his, and that he in fact was living in that residence, or at least associated with that residence, and gave some information to the police, but that was after the fact. And I think that if defense counsel had been more diligent and lived up to the standards of effective counsel, that there may have been a challenge to that search warrant that was not done in this particular case. Thank you very much.
Thank you, counsel. You'll have a full 5 minutes for rebuttal if you need it. Good morning. You'll have 15 minutes, counsel.
Good morning, Your Honors. May it please the court, Lindsay Poprocky on behalf of the appellee, State of Ohio. In his merit brief, the appellant, Stephen Atkinson, framed the issues in the appeal around the fact that his trial counsel filed an untimely motion to suppress. He claimed that as a result of the untimely filing, he was improperly denied a hearing on his motion and denied the effective assistance of counsel. The state viewed the issues in the appeal less about the timeliness of Atkinson's motion to suppress, but rather about its merits. It was undisputed that Atkinson's trial counsel filed a motion to suppress which was untimely and denied by the trial court. As we've heard, Atkinson's trial counsel did seek reconsideration of the decision denying his untimely motion to suppress, which the trial court granted. The trial court then proceeded to consider Atkinson's motion to suppress on its merits and denied it without a hearing. Although the trial court considered the motion to suppress without granting Atkinson a hearing, the state submits that he was not entitled to a hearing under the U.S. Supreme Court's decision in Franks v. Delaware, which was the basis upon which he grounded his motion. He challenged the veracity of the affidavit in his motion to suppress, supporting the search warrant which authorized the search of his residence, and on appeal contends that the search warrant affidavit was illegally deficient. At the outset, the state would note that a search warrant supporting affidavit enjoys a presumption of validity. The U.S. Supreme Court and this court have squarely addressed when a defendant is entitled to a hearing on a Franks challenge and concluded that a hearing is not automatic. I believe defense counsel has even conceded that to mandate a hearing, a Franks challenge must consist of more than conclusory statements, and there must be allegations of a deliberate falsehood or a reckless disregard for the truth. Those allegations must be accompanied by an offer of proof. An attack on an affidavit should point out specifically the portion of the warrant affidavit that is claimed to be false and should be accompanied by a statement of supporting reasons. Affidavits or sworn or otherwise reliable statements of witnesses should be furnished, or their absence should be satisfactorily explained. Here, the state would submit that Atkinson's trial counsel failed to make a sufficient preliminary showing to entitle him to a hearing. In his motion to suppress, he did not include any specific references to the portion of the affidavit which he challenged, or the portions of the affidavit which he claimed to be false. Rather, his motion to suppress challenged the reliability and trustworthiness of the confidential informant and insufficient investigation to corroborate the CI's information. He basically just challenged the reliability and trustworthiness of the confidential informant without pointing to any false statements made by the affiant in the affidavit. Based on these conclusory statements alone, Atkinson asserted that the affidavit contained false statements that were intentionally made and which should have been excised under the affidavit based on Franks. The state submits that Atkinson failed to make a substantial offer of proof to entitle him to an evidentiary hearing, and that his first assignment of error should be overruled. Under Atkinson's second assignment of error, he asserts that he received ineffective assistance of counsel because in his merit brief, the argument was that he received ineffective assistance of counsel because his trial counsel failed to file a timely motion to suppress. That was the argument in his merit brief. As this court is aware, to prove ineffective assistance of counsel under the standards set forth in Strickland, counsel's performance must be deficient, and the deficient performance must cause prejudice. In his merit brief, Atkinson argued that had his counsel filed a timely motion to suppress, the motion likely would have succeeded. Again, the flaw in this argument is that trial court successfully filed a motion for reconsideration of the entry denying his motion to suppress as untimely.
If the motion was timely filed, would the court be required to hold a hearing on the motion?
I don't think so, because the motion to suppress was still grounded in Franks, and he would have still had to show an offer of proof to entitle him to a hearing, even if the motion was timely filed.
how do you show an offer of proof if you're challenging the veracity of the confidential informant? Especially, that that name was not released to the defense here, and I understand that, but what was he supposed to do in that aspect of the search warrant?
That's where I think he had to show a false statement on behalf of the affiant, where the affiant made some false statement regarding the confidential informant's investigation.
How is he going to do that without having the affiant on, without
He
hearing?
would have to provide a witness statement or some affidavit to support his Frank's challenge.
Okay.
Because the trial court in fact reconsidered its order denying Atkinson's motion as untimely and proceeded to consider his motion to suppress on its merits, Atkinson did not suffer any prejudice as a result of the untimely filing. His motion to suppress was ultimately considered by the trial court. For that reason, Atkinson's argument fails under the second prong of Strickland. The state further rejects Atkinson's suggestion in his reply brief that the state conceded ineffectiveness by demonstrating the deficiency in trial counsel's Frank's argument. Here it is the defendant's burden to establish ineffectiveness of counsel, and in doing so, he must establish that there is a reasonable probability that but for counsel's unprofessional errors, the results of the proceedings would have been different. Atkinson cannot meet that burden. He has suggested many other avenues in which the search warrant could have been challenged, and he has done so here today by illustrating facts that are not in the record. And notably, the state would submit that the search warrant is not in the record for review. In that regard, Atkinson's claim for ineffective assistance of counsel is necessarily based on documentation outside the record. For these reasons, Atkinson's ineffective assistance of counsel argument fails under the second prong of Strickland because he cannot demonstrate prejudice or how the results of the proceedings would have been different, but for his trial counsel's alleged errors. We would ask that this court affirm Atkinson's convictions and sentence.
Questions? Okay, thank you.
Thank you.
Attorney Bradley, you have up to 5 minutes, if you'd like.
Please, the court. So, the defense counsel files a motion to suppress. He does not include any supporting affidavits or other evidence to warrant the motion to suppress, and he has filed an untimely motion to suppress. The court denies it as being untimely. Defense counsel then files a motion for reconsideration. Again, in the defense counsel's motion for reconsideration does not include any affidavits, any supporting evidence, nor argue that because defense counsel was not supplied the name of the confidential informant, that it had no way of providing such information to the trial court. In the motion for reconsideration, the defense counsel just simply argues the trial court should grant a hearing on the motion to suppress because that would be the fair thing to do, basically. The state of Ohio makes a good argument for me, and that is that defense counsel failed to file a motion to suppress that complied with Franks versus Delaware. And because the state makes that argument, I believe the state is conceding the fact that defense counsel was in fact ineffective. Whether they filed the motion timely or not, they had an opportunity, basically a second bite at the apple, to supply the trial court with the information required under Delaware versus Franks. Defense counsel cited in their motion to suppress Delaware versus Franks, and yet provided no information either the first time or in the motion for reconsideration as to why the court should grant a hearing. So, and then they didn't even ask for a finding of facts and conclusions of law. So I believe in a case like this, especially when somebody is looking at 11 years mandatory incarceration, that defense counsel's performance in this particular case was below standards, and that this court should reverse this case so that a proper motion to suppress can be filed in this case and a hearing can be had to determine whether or not the search on Sterling Road in Lorain, Ohio was in fact a valid search. Thank you very much.
Thank you, counsel. Thank you each for appearing this morning for your arguments. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the court's decision to each of you on the day it is released, and you may also watch for the opinion on the Supreme Court of Ohio's website where the opinions are posted. Thank you both again for your arguments.